Okay, what's up, people? Well, at one point, you could actually see me. I'm not sure why you can't now, but anyway, we'll make this another quick one. Because this one, and also as you come in, hit the like button. As you come in, hit the like button. And I guess I am dark enough where you can see my teeth. Anyway, today I'm going to talk about Sterling Brown and why he's able to sue the police officers that tased him for the parking infraction a couple of days ago. Well, I did a video probably a couple months back where it talked about holding a supervisor liable. When you go back and look at the video and you see Sterling, he's confronted by one of the officers. Then it goes into the officer makes a call, and then all of a sudden there are up to 11 officers that are on the scene. What happens is the fact that there's this thing that police like to use called acting in concert, which you're able to tie to their activities. Also, when they breach their fiduciary duty, they lose their immunity. The reason their fiduciary duty was breached in the Sterling Brown incident was because when he came out, it was not for a crime. So what's up, Joshua? So for the overbearing of multiple police units, I believe it was 6 police units in total by the end of it. So once that happened, it is no longer a police situation. It is no longer a traffic situation. And so again, anything that happened beyond that became things that went against their fiduciary duty or their qualified immunity. And they were no longer actors of the government, which is why I state when you take them to federal court, because what they're violating when they violate the fiduciary duty to you is they are violating federal law. They are violating the Constitution. They are violating their restrictions. And in doing so, the only place that you can actually hold them liable is in the place that they are subject to, subject to, and that's in federal court civilly. And you do it in their personal capacity. You do not take Officer Johnson. You take Joe Johnson, not the basketball player, but Joe Johnson in the court. And you do it in their personal capacity. Now, a couple of cases that I spoke about before, again, because we spoke about the supervisors, because they claim that they did discipline to several of the officers. They won't tell you which ones, and they won't tell you what exactly the discipline was. But they will tell you the three initial officers that were on the scene were suspended. Again, no elaboration on that. But they also suspended their supervisor. Now, the reason why that's important is because when they spoke to the sheriff regarding the information after the video was made public, he spoke about all the officers needed retraining on how to deal with the public. Because you remember a couple videos ago, I spoke about they are trained to deal with the public properly. None of those guys did a proper introduction with the public or interaction with the public, which is why their liability, they became liable personally for their actions. And then the supervisor is liable for the action of their subordinates. Can't speak right now. So therefore, him going into federal court is the right thing to do. And the case that I want to bring up was Monroe versus Pape, P-A-P-E. I'll actually put it in the description. So if you need it, I'll actually it'll be there before the night's over with. And Pape speaks about why they lost their qualified immunity and going into what it is that they did to get to the point that they're at. And then we go, and I'm going to spell this one out. And this is the reason why the supervisor was held liable, because of Steidl v. Fermon, Steidl v. Fermon. I'm also going, there it is, Monroe. Appreciate that, David. And further, Steidl v. Fermon. That is why the supervisor is liable for the action of their subordinates, because when he got there, he did not stop anything that they were doing. He encouraged it. That encouragement is an accepting of liability. Now, the one thing that caught my attention was the fact that the police chief himself spoke against the actions of the officers, which he should. But the commissioner, the police commissioner, stated that tasing Brown was also the right thing to do. Now, if it was me, I would go amend the lawsuit if it has already been filed, because I don't know from what his lawyer has put out. It does not state if he's added the police president, or hold on, let me look, because I don't want to say it incorrectly. The police union president stated that tasing Brown was correct. And the one thing that I found interesting was when they would, and the mayor, good, yeah, because I knew it was somebody else as well. But the reference that was made by a young man, I'm not sure if anybody's heard of him, but I believe it was Sean King, when he spoke about there needs to be something done or in the retraining of the police officers, because they're trained at this point to hunt people down in the street. And that by no means is the actions of a servant. And by making a choice to be a servant and choosing not to do their job properly, suing them in their personal capacity is the best thing to do in federal court, because they do not deserve to wear the badge. Because if they can't do what they chose to do, which they made a conscious decision to do, then anything that they've benefited from doing that job and not doing it correctly should be taken from them. And you know, I hate to be that way, but again, just like I spoke to David once before, if I order a T-bone and they bring me back a ribeye, most of them want me to be happy with the ribeye because they're giving me a steak. The problem is I can't be happy with the ribeye because I ordered a T-bone. You want me to be happy with the steak I get, bring me the steak I ordered. And that's where the disconnect is coming from, which is also why I am so adamant about whenever somebody violates their duty, they don't want to do their job anymore. So take it from them. Because we know as a people that the police are not going to police themselves. They are not going to do anything that compromises their business, because the legal system is not a system of justice. It is a system of money. It is a system of time. And those are things that we need to combat, which is why I speak on the things I speak on. And I'm talking about how to enforce our stance and our abilities when we are dealing with them, even in a day-to-day basis. Because I have brothers that are police officers, that I have friends that are police officers. And in certain settings, we don't have casual conversation because I understand how they're trained. I understand their mentality. Now, do I have conversations with them? Yeah, but I understand what type of conversation I can have with them. Because even in the truest sense of who they are and who I am, it's not that I'm not being genuine with them. It's not that I have anything to hide from them. It's the fact that they're not on my team. As much as I would love for it to be, they're not on my team. Because when it comes down to it, they're going to back the blue. Because that's where their career is tied up in. That's where their job is tied up in. That's where their retirement is tied up in. So they're not going to ride with me, and I don't expect them to. But again, going back, the reason why Sterling Brown is able to sue is because they violated their fiduciary duty to him. They acted in concert from the initial officer's call to the officer's orders to tase him, which was bodily harm. Nothing that was done was for his benefit. And that breach of duty then fell upon the supervisor, which now the supervisor is being held liable in the lawsuit. But he can't have an amended lawsuit because of the police president, union president, stating that it was okay for the actions to continue because, again, he is a supervisor to the supervisor and can be held liable for all the actions therein. So that's all I got for right this second. I'm going to look over here in the comments real quick for a couple minutes to see if anybody have any questions I can answer real quick. But if not, I'll see you guys tomorrow. Hopefully I'll be able to post something. All right? And I appreciate you guys for commenting and showing up. Yes, sir. Question from David. Hello, Beware Mouse. Okay, 18 USC 1943 or 45. Okay, hold on. Can an 18 USC 1001 be used for false statements? Yes, but again, that's going to be something that you use after discovery phase. So it'll be you file. Actually, let me slow down real quick. Okay, what I would like for most people to do, whenever you go in and you begin filing, one of the first forms that I want you to file is the file that you will be representing your own interests. Because a lot of times they'll wait to the last minute to try to force an attorney on you. They'll try their best to force some type of stand-in puppet for you. This way, it's already on the record that you are representing your own interests and you don't need help. Secondly, you file the complaint, which is actually the motion to get you in federal court. Third, you will file a motion for discovery after you, because generally when you'll do that, because it'll be included in something that you're removing to federal court. So that discovery motion will be in that. That's where you will file that the 18 USC 2001 in federal court, because it'll be to contradict anything that is you find in the discovery that is not based on either fact or it is something that they made up. So yes. Okay, how about Beware Mouse? How about giving notice as to the law at the time of contact? What about injunctions? Can you do them directly after arrest? Okay, injunctions first. Again, I file the injunctions once I do the removal to federal court, because anytime you're dealing with them, there's no need in going to state court. There's no need in going to superior court unless. Superior court is an unless, but traffic court doesn't exist. So that's bullshit. So you go ahead and remove that to federal court and get that out the way. And then once you get it in federal court and you have a case number, you immediately file the injunctions for whatever that you're filing the injunction for, and you set it for hearing. Now, in each courtroom, they have a different means of doing that. Now, because you are not a bar member, when you set it for hearing, you actually will do that with the clerk that you file your documents with. And you will do that once you remove it to federal court. So I hope that answered that part of it. And then the second part was, how about giving notice as to the law at the time of the contact? 90% of the people that you come in contact with as far as police officers, I found most street cops have no idea what the fuck the law is because they are code enforcement or safety enforcement. They have no idea what law is because they don't study, which is why a lot of times people say, all right, we'll call you supervisor. Why? Because the supervisor is in a different position to know law. So therefore, but that's also a double-edged sword because they know when you're saying certain things, if you say and if you assert what you're supposed to say and then shut up, let their time tick on. And that's because Sharp v. US only allows 19 minutes and 50 seconds for the most part of any type of detainment. And within that time, they have to articulate a crime. And any detention longer than that, then you have a conversation with a federal court judge. Because if you ask for a supervisor, the clock stops. If you are smoking weed for whatever reason, or they can smell alcohol because, you know, it's happened. People drink, people smoke weed. If you're doing it in your conveyance, that authorizes them for the most part. You're rolling down your window, they see smoke coming out, or they can smell the weed on you, or they can smell the alcohol, you know, coming not only from you, but from the car, and they call a dog. Well, the clock stops. And understanding that is understanding if they don't know, don't force it because you're not going to change their mind. So don't worry about trying to do that. 19 USC 1983, 84, and 86. Okay, you got a ton of stuff that you got going on down here. And Joshua, yes, start the clock on detainment. Because, see, you have to understand each one of the case laws that I give you are situational. Because even when you look at a Terry stop, there are multiple facets of a Terry stop. When you understand Miranda v. Arizona, it is multiple facets to Miranda v. Arizona. So when you're looking at applying a particular case, you also have to understand how that case applies to your situation. Now, which I'm going to start going over, you know, probably in the next month or so, is we're going to talk about how to break down, and let's say when you understand putting it and presenting your case in front of a judge, most judges don't want to read a 20-page motion because most judges are not going to read a 20-page motion or a 20-page complaint. So what you want to do is be concise as possible. This is what happened. This is the case law that applies to this infraction. This is what I'm looking for to happen from this particular infraction. Because we all know employing the emergency services, such as turning on their lights. Because you hear a lot of people, oh, that's a felony. Why is that a felony? Because there was no emergency that was taking place. Now, that's Fourth Amendment violation because they come up and just say, oh, well, can I have your driver's license and insurance or whatever? And you ask them why, say, oh, I'll tell you in a minute. That's insurance fraud because they have to tell you because they are amenable to you at all times. Why? Because they have a fiduciary duty to you. Part of their duty is to let you know what's going on and how it is going on. Okay, then voluntary servitude mentioned, which is a crime in all states. And how much standing does that have against this corporation? Okay, involuntary servitude becomes when you talk about probation because I believe it's Bannon v. Georgia, and I believe it's a 2012 case where Supreme Court ruled that all probation is illegal. Why? Because they're threatening your liberty for a debt. And What is the debt for? You didn't purchase anything. So you're paying them to be free. That's illegal, which is also why I spoke about child support. Child support is a unilateral contract because what are you getting? It's not mandatory that you have to see your child, but the state is telling you you have to pay them money and they decide how much they're going to give to your child every month out of what you give them. And from that, let's say you miss a month. The first thing they do tell you is if you don't pay us, we're going to throw you in jail. That immediately makes it federal. Why? Because that's involuntary servitude. That is a federal court issue. You remove that or that statement, that letter, whatever you get, and you take it to federal court. Why? Because that's your evidence of involuntary servitude. Okay, City of Dallas, to take away all remedy for the enforcement of a right is to take away the right itself. Shoot, I got you. Beware, mouse. And you are correct. Title IV court has no authorization, as all courts are common law. Now, you also have to understand where the application for all courts are, because one of the things that I always advocate when a police officer decides that he wants to hand me a citation, the first signature on it is viet armis. Because I don't give a shit about how I sign it. I can sign it correctly. I can sign it, with my, my government name for the most part, and just sign it viet armis. Why? Because Latin is what moves the court. And then understanding that the contract itself, there's an element that's missing. So now I go and get a copy of his oath of office. Why? Because that's proof of his fiduciary duty to me. When he goes up, I'm not paying for that ticket. Because generally what it takes is about 4 days for him to generate a report, which he then presents it to the court for a hearing. That's why they generally give you 30 days, because most of them are lazy as shit. So now once you have a court case, they assign it to a judge. I go get a copy of the attorney information, which is most of the time their bond for the court. I also go to get a copy of the judge. I get a copy of his oath of office. Why? Or her oath of office. Why? Because they have a fiduciary duty to me, because they are trustees of the public. My next thing now is I have these oaths of office. I go and file the paperwork that I just spoke about in federal court as part of the removal. And this is their evidence. I then attack the ticket, the citation. I then attack their duties to me and how they were breached. And I'll either file a motion for dismissal, or if they've done other things, I'll go back and file injunctions to seize their assets. I'll go and file multiple injunctions to do certain things to, basically get on their nerves just like they gotten on mine. But for the most part, that's where we're left off at. So yeah, those are great things. All crimes are based in hate. I see we're gonna have to have Mouse on the show one day, because Mouse sitting up here you going all deep. You going all deep. I feel you, Joshua. But yeah, I'm gonna give you. Hold on, I'm actually. So the next one you get, that's what you put in it. Viet armis, because you understand the courts are built on Latin. That's why you always hear things such as nolo contendere, or you have other Latin phrases that are being said in court. Most people have no idea to what's being said or what's being done. So I'm going to go. I'm going to go deeper into the Latin portion of it because I'm coming towards the end of holding police liable. Because again, you know, I think tomorrow I'll probably do something with the Bain Act and maybe a couple others, even with the 1943 and even the criminal and civil portions of it, and give you kind of a connection with provost marshals and give you different introductions on who and why. Because also, if you remember in the Sterling Brown incident, the governor actually stepped in. And you have to understand it's codified that the governor is the one that appoints the trainees for all the police officers. So therefore, whenever you're getting ready to sue a police officer and or the state, you have to notify the governor and you have to allow the governor 6 months to rectify the situation. If you think about the Sterling Brown incident, it happened 6 months ago. That's why we're just now finding out about the tape now. This has been going on for 6 months. He's gone through the proper channels. So therefore, he's going to get the remedy he's looking for, whatever it is, whether it's monetary, whether it's a couple of these bastards fired, which it should be a couple of these coward asses fired, and he's going to get them retrained. And no, I did not have an opportunity to speak with Freeman. And Mouse, Miles, see if you can hit me with a direct email or something, or shoot me your email and we'll go from there. So y'all hit them like buttons for me. If you have any questions, just let me know. I appreciate you, and I'll see you guys tomorrow.